So you got to understand, these people have no problem keeping your kids away from you for the rest of their lives. So, but you don't look at them like, I hate you, I hate you. You just say, this got to be stopped, and I'm not going to knuckle down and just be intimidated by you folks.
Exactly.
This is my court. These are my rules. I have this right according to, natural law. You don't have to use God or the supreme being. You have a natural right. You have rights to control your property. And the church gives you any nonsense about the property. I'll try to find the John Locke quote. Because it's like, he's saying, well, Lincoln freed the slaves. It's like, yeah, but what did John Locke say about property? Property is what a man claims that is property, his person, exclusive to all others within a society, for him to enjoy exclusively of all others. Is that not property? Like my heartbeat and my dreams, my hopes and my desires, is that too not my property? And let him baffle that little ditty. And he'll say, well, okay, well, then I guess John Locke kind of does trump Abraham Lincoln. It's like, yeah, because that's where Abraham Lincoln got his knowledge from. So don't, you want me to trump you? I'll keep trumping you all day. You just little, look before you leap. And then I'll say, well, he who hesitates is lost. You want to play your little ditty games with me? I'll play your little ditty games all day. The bottom line is, does anybody have a claim to that property other than me? Yes and no. And it'll be that simple. And thank God in a common law country, no. In France, if that child is part of society, you have no inherent right to that child if you agree to abide by the customs and traditions of that society. That child is part of the community. That's what they're trying to do here. In this country, they're trying to make the child a part of a community.
Yeah.
And that's fine. There's a lovely concept. It's kumbaya and hugaboo and stuff like that. That's lovely. Maybe one day they'll figure out the DNA human being and get rid of all the anger, lust, greed, gluttony, avarice, fear, hate. They'll eradicate that gene, and we'll all be lovely, happy creatures. But until that day, I don't want nobody touching my kid because I don't trust nobody.
That's right.
With my kid, that's my kid. Don't tell me you have good, will for my kid. I will only do what I will do for my kid, and nobody else will do what I will do. And you don't have to explain it to anybody. It's universally accepted that everybody understands this concept about a child and a mother.
Yeah.
So you don't have to go about that. But what I would do if I was you, establish the rules of court, give them in the form of a notice, explain that the honest court is going to be holding a preliminary hearing for the return of the property, and if there's any claims that come forward, the trial by jury date will be set 1 week from now. And there you go. And if nobody comes forth with a claim for the possession of this child, this man in the black robe before us, who's ever going to sit before us for a representative of this venue, a representative of this, whoever the court clerk assigns to sit before us, he's going to take he's going to be witness to what occurs today, the event, that nobody came forth with a claim, and that my order for the property, 1, 2, and 3, 4, also known as children, are to be returned to its original place of origin by 1 a.m. And then once you get that order, then you go to, well, I don't know if you folks have sheriffs in the Mounties, then you could bring that order down to the sheriffs in the Mounties and say, help me regain my property.
Right, here it would be the sheriff.
Right, because like I said, if they say you want to do something similar to what you folks call a writ of attachment or writ of sequestration, that's fine. But a writ of sequestration is more like saying, if you really thought MOSD folks, whatever the people out there, the social service people are hurting your children, you could move for a writ of sequestration and say, I want those children, my property, removed from those people because I think they're in great danger and harm. And if you could, can you relocate them? If you don't want to put them in my custody and care, can you please bring them over to a Catholic orphanage? Because I trust those people more. You see what I'm saying? That's a writ of sequestration. I'm not saying you're doing this for you. I'm just making this available for ideas of other people to use in the future. Not this isn't for you alone. I'm just saying, throwing it out there for other people who might listen to this stuff.
That's right. What the different options are that are out there that are available.
Right. If you real fear that the social service people who are holding your children at certain providences or states are actually placing with a maniac family, or do you say, well, what we gave social services a hard time, so they're going to pick the worst foster care family to put my children in, so my children get beat up because we won't just knuckle under and sign damn contracts. You make a motion to the court we'll explain motions and orders some other time. You order the court that you want your child removed from that place and placed someplace else. And we'll do that some other time. Somebody wants to talk about a writ of attachments or writ of sequestrations, and we'll do that some other time. But your big thing was when you walk into court, how you act, set up the rules, say why I'm sitting on the left, because it's just custom to you people so you don't freak out the guys taking over the right-hand table with them. We will sit at the left-hand table. But at no time do you think that I'm not prosecuting a claim, that property is mine. And regardless of where I'm seated, the fact remains, if a claim doesn't come forth before this court by 10 a.m., the clerk, the magistrate is to recognize and witness to the court clerk that she is to stamp our orders and to deliver upon us. And then you can do whatever you want with that order. You can go down to the sheriff's department and say, well, I got an order. If the sheriff says, well, you know what, we like writ of attachments. So why don't you go get us a writ of attachment or, like a warrant in debt, go get a warrant for us and we'll go get it. And then I'll explain to you a little bit about bonds and stuff like that.
Yeah.
Right now you don't really need to know all that stuff. So this was just basically how to act when you walk into the court and how to just kind of try to get away from all that crazy should we stand up? Should we rise? Should we speak? Should we not speak? And like I said, the best thing to do is you give them the rules. As long as you give them the rules prior to being there, everybody knows what's going on. And it's like, sir, did you not read rule number 2? What? If anybody's making a claim, they could bring the claim forward to me. Or they could hand their claim to the bailiff, and the bailiff could hand you a copy, and the bailiff could hand me a copy. Why am I not getting a copy of the claim? I'm going to be the one who's going to judge whether or not we're going to share this property. And if I choose not to share this property or the proposal that they're throwing across the table at me, I'm going to say, you know what, we've reached an impasse, and now we have a matter of controversy that is going to be standing for all times again between us. So we are going to have to move this before a trial by jury. And does everybody have a problem with us being here next week, same time, and getting the jury convened and let the show get on the road? Anybody have an objection to that? Because, like I said, court's open 24 hours, 7 days a week. You could hold trial by jury at 3 o'clock in the morning. There's really nothing they can do about it. I did that to a judge. Tommy said, oh, Carl, please, let's be reasonable about this. He says, can we convene in 14 days? I said, well, let me tell you what. How about we do it in 30 days? He said, 30 days? He said, court was open 24/7, 365. I said to the judge, if I call you up at 1 o'clock in the morning, what happens? He says, I'm supposed to call the state's supposed to convene, we're supposed to come down here and hold trial. I said, that's right. He said, Carl, please, can we be reasonable about this? I said, what do you propose? I said to the judge, the hearing officer, what do you propose? He said, how about 14 days? Give me 14 days because I live pretty far away from this county. He was coming up from Montgomery, a Bibb County down there by Montgomery. He said, can you give me a little heads up? How about 14 days? I got things to do in my courthouse. I said, okay. So I said, how about I give you 30 days? He says, wow, that's great. 30? He says, that's very reasonable. I said, buddy, I got to come from Virginia. I got to lock up a farm. I can't be here at 1 o'clock just because I wake up and say, oh, the King's convening court. It's 1 a.m. Everybody chop, chop. I said, I still got to drive 600 miles to get here. I said, so believe me, 30 days is fine by me. He's like, oh, well, God bless you. At least you're reasonable about this. See, when you really know the rules of the court and that who's running the court and that you're the prosecutor and you're the king or queen, you're the one who's calling the rules. And they have a certain established set of rules. Court is open 24 hours. Well, here in America, here in the United States, it's 24/7, 365. So I don't know what it is in Canada, but the rules that are well established, and you can find it in every single constitution or every single code book in all these states. It always says the same thing. Courts are never closed. So they might just make a simple word like that, courts are never closed. That doesn't, so when you say, well, the door closes at 5 o'clock and what, you could always go to the sheriff's department. He'll ring up a magistrate. The magistrate will come down, and you can conduct court in front of the magistrate. He's a witness that you brought the claim at 2 o'clock in the morning. Or that you're filing a criminal complaint that somebody broken into your husband, busted your nose. The magistrate will wake up and come down and take your claim. The sheriff will go arrest your husband at 2:05, and there you go.
Yeah.
Then when the clerk of the court opens up for business at 9 o'clock, the magistrate will just hand you the paperwork. Say, this is what happened last night while you were sleeping. file it, put it, give it a case number, routing number, whatever you want to wish to do, court clerk, and I'm going back to bed. So is there any other questions you really had about Wednesday?
No, I think that really helps kind of clarify the process. So what would we title our notice that we're sending to outline the rules that we're
Notice. Notice.
Just a notice, okay.
All lowercase. Notice. And underneath this, say notice of, and then say our notice, and then underneath it, you could do I like to do it, rules of court. You could make rules with an uppercase R and court with an uppercase C, because what you're saying is, by doing one uppercase like that, you're saying you believe court has duties, responsibilities, and obligations. You're saying the court has no rights, but what you're saying is the court has duties, obligations, and responsibilities. So when you say rules, you're saying that we have no rights, but what we have is duties, obligations, and responsibilities to abide by our own rules. Like if we operate outside of these rules, you make the king and queen aware that we're operating outside of our own parameter and rules that we establish for this court, and you could hold me in contempt of court. You see what I'm saying?
That's right.
You could be held in contempt of your own court. So that's why, like I said, make notice in lowercase, but I'd make the rules of court, rule uppercase R, and C uppercase C. Mm-hmm. And then, when you do the on-nest court, like I said, you could do it in all lowercase like that if you want to, because you believe you have exclusive rights to everything within that on-nest court. The on-nest court could be all lowercase, that's fine.
Okay. Can you spell the on-nest court?
Yeah. Mm-hmm. Oh, yeah, and then every time you want to refer back to the on-nest court, just say Fed court, S-A-I-D court. That way you don't have to keep saying on-nest court, on-nest court, keep saying said court.
And how do you spell the on-nest court?
What's your last name?
Oh, you were using our last names. Okay, yeah, so the Arsenal court.
Okay, well, you wanted everybody to know Arsenal.
Okay.
That's what I was saying on this, kind of figuring that you you knew what I meant. So, okay, if anybody's listening to this call, you use your last name. Because if you look at any Supreme Court rulings, like Hale versus Hinkle, it'll say in the Hinkle court, the lower court decided this. And then it moved up to the Circuit Court, the Court of Appeals in New York, and in the Hinkle Court at the Court of the New York Superior Court and New York Supreme Court, the New York Supreme Court in Hale versus Hinkle ruled that the accountant for the banana fruit company, Mr. Hinkle, was denied. So Mr. Hinkle now has brought it before the Supreme Court. So the Hinkle Court has now moved into the Supreme Court of the United States. So what it is the Arsenal Court now is now moving into this venue. It is the Arsenal Court. So what you folks will call the Arsenal Court, and then you can put the word at, and then say what court are you actually appearing in, like the New Brunswick District Court?
Court of Queen's Bench.
Okay, is that all it's called? Is it called the New Brunswick Court of Queen's Bench?
We actually called it the Jacinthe and Jonathan Court.
Okay.
In our paperwork.
What I'm saying is, what do they like to title or stylize on their letterhead? How do they like to address themselves?
They refer to it as the Court of Queen's Bench of New Brunswick.
There you go. Beautiful. So you say it's the Arsenal Court at the Court of the Queen's Bench of New Brunswick. Exactly the way they stylize it, uppercase, lowercase, however they like to do it that way, because it's just a cause at this court. Because you basically everybody knows where this building is. So instead of being cute, you're saying, does everybody know the name of this? And they say, yes, okay, fine. Then the Arsenal Court at Queen's Bench, blah, 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 blah. We'll have a hearing, blah, blah, blah. There you go.
And, so I think, basically we're outlining our rules of court. We're the prosecutors. We need the minister to come forward to press for a claim on the record if he has one.
You leave it vague. You don't say you don't say any. You say we are accepting any and all claims. You don't really use prosecutor, because prosecutor means you're just a hunter. You know you're a hunter. Okay. So it's like to hunt for deer or something like that. I don't have to say Carl the hunter. You see what I'm saying? Mm-hmm. You don't have to keep defining yourself as a prosecutor. So all you have to do is say the on-nest court is accepting all claims to property 1, 2, 3, and 4, C exhibit, whatever. And then you can even put their lovely birth certificates and anything else you want to do. That's fine.
Okay.
But to say the property known as 1, 2, 3, 4, C exhibit 1, 2, 3, 4, that's fine. And say we're accepting all claims, and may all claims go, and we accept all claims from 9 o'clock to 10 o'clock. And it's just simple like that. Don't direct them personally, because what you're trying to establish is people on the right-hand side who don't even exist. They're phantasmagorical, whatever apparition that somehow believe they have an opinion or a voice that should even be heard. You see what I'm saying?
Yeah.
You're trying to make it like they don't even exist. I don't even know where these people get their authority, power, jurisdiction. I don't understand why these people are in this building at this time. I have no idea what makes them think they could do what they're doing. So you see what I'm saying?
That's right.
You're trying to basically, talk to the hand. I don't even know what you are. I have no. You're just some rule book that sprang out of the ground 2 years ago. My kids are alive a lot more. There's agencies on this planet.
That's right.
See, so that's try to be vague about who's making the claim. You see what I'm saying?
Okay. So we're basically, our rules of court, when we lay them out in the notice, we're accepting all claims from, say 9 till 10. And, if nobody brings forth any claims by 10 o'clock, then we want the judge to basically record that the other party didn't show up, nobody pressed a claim against for their kids.
Instead of saying the judge, say the representative of the court clerk's office. He's going to be a representative of the court clerk. Who's ever been assigned to the court's office is to witness that no claims have come forth. Okay. And that he or she is to take bear witness and take my order and present it to the court clerk and have the court clerk file it and return it to me as a witness that no claim has come forth.
Perfect.
There you go. You want to get away from looking at him as a judge. Like, this isn't a beauty contest. This isn't American Idol. He's not the judge.
That's right.
And if the magistrate, the guy in a black robe, says, no, ma'am, I'm sorry, but the MSO Social Services did bring forth a claim, so we can't bring this to the court, and we can't have your order stamped and filed at this time. So good. Then you read the rules. If you believe, if the assigned person, the court clerk's office, at this time believes that there is a claim before this court, a counterclaim to our claim, then we want the trial by jury set up as soon as it's available room in this venue to see the jury. And we say we'll come in midnight. We don't.
And don't care what time it is.
Right. They'll understand. You can put that. Court is never closed, and I'm sure you can. That says that.